Hi, this is Peter Schiff. It is Thursday, June 27th, 2012, a date like December 7th, 1941, which should live in infamy as a very sad day for America. The Supreme Court today, in a 5-4 decision, upheld the Affordable Care Act, otherwise known as Obamacare. At least there were 4 justices that cared enough about the Constitution to actually dissent in this horrific opinion. And a lot of people think, well, the Supreme Court is not there to interject itself between Congress and the bills that it enacts, that if a piece of legislation is passed by the Congress and signed by the president, the Supreme Court should simply defer to their judgment. That is not why they're there. The Supreme Court is there to enforce the Constitution. And if Congress and the president want to do something that is not authorized by the Constitution, the Supreme Court is bound to strike it down. That's why we have a system of checks and balances. The Supreme Court is not a rubber stamp on Congress. It is supposed to check Congress. And in this circumstance, it did not do that. It did not honor its responsibilities, and it did an extreme disservice to the Constitution, to America, to the American people, to individual liberty, to limited government. I'm going to spend some time on this video blog just getting into the elements of this decision and show you exactly why it is in fact so wrong. First of all, in order to uphold it, the Supreme Court had to say that the penalty for the individual mandate, where you are required to buy health insurance or be subject to a penalty, the Supreme Court had to declare that penalty a tax. You see, a lot of people thought that they were going to look towards the Commerce Clause and say that, well, Congress can regulate interstate commerce, therefore they can force you to buy health insurance. The Supreme Court, to their credit, did not buy that argument. They said that the Commerce Clause does not allow the government to force people to do something. But what they did do is look to the taxation clauses and say, well, Congress can levy a tax, and they looked at this penalty as if it were a tax. Now, the justices that dissented clearly said that's not true. This is not a tax, it is a penalty. Just because money goes from a citizen to the government doesn't necessarily mean it's going there by way of a tax. You see, a tax is an exaction from the public to government for the purpose of raising revenue. So the principal purpose has to be to generate revenue. That's what makes it a tax. If that's not the purpose, then maybe it's a penalty. Now, the Supreme Court tried to argue that, no, that's not the case, because they said we have an alcohol tax, we have a tobacco tax, and that punishes people for smoking or punishes people for drinking. Therefore, we have those taxes that are meant to alter behavior. Therefore, we can have this tax. Well, that's not true. Because the principal purpose of the alcohol tax is not to stop people from drinking. It's to raise revenue for the federal government. If they wanted to stop people from drinking, they would just raise the tax up to the point that nobody would buy alcohol because the tax would be prohibitively high. They did not do that, right? In fact, if the government could simply levy a tax on something that it had no constitutional authority to prohibit, well then, the government could do everything it wants. In fact, the Supreme Court actually said that the Constitution does not authorize the government to force you to buy insurance. But then they said they can tax you if you don't. Well, that's a distinction without a difference. Because if they can tax you, they can make the tax so high that you'll have no choice but to buy the insurance. Now, if you think about their argument with respect to alcohol taxes, see, it's not true. Remember, the 18th Amendment made it illegal for Americans to buy alcohol. Now, why didn't Congress just have a very high tax on the sale of alcohol and accomplish the same thing? Well, because if they had had a tax that was prohibitively high, it would have been struck down as being unconstitutional. Because it is a settled legal principle that Congress cannot do through the tax code what it lacks the power to do legislatively. So if they don't have the power to force you to buy health insurance, they can't tax you into buying health insurance. Now, the Supreme Court actually acknowledged this, and here's where it really gets crazy. The Supreme Court, in upholding the mandate and calling it a tax, they said that because the penalty is low and relatively insignificant relative to the cost of insurance, that it's really ineffective and that it really doesn't force you to buy insurance because you can just pay the tax, which is actually cheaper than buying insurance. In other words, it's constitutional because it's ineffective, right? Because, for example, take my situation. I think if I don't, based on my income, there's a cap, but if I choose not to buy insurance, I have to pay a $2,000 penalty. Well, that's not going to force me to buy insurance. The penalty is less than it costs me to buy insurance. I just won't buy insurance and I'll pay the penalty. But actually, the Supreme Court went another step further. The other reason the Supreme Court gave for justifying this tax by saying that it doesn't actually force you to buy insurance, apart from the fact that the tax is low, is that there is no enforcement mechanism where the IRS can force you to pay it. Unlike income taxes, where if you don't pay your income tax, they can garnish your wages, they can levy your bank account. The law specifically forbids the IRS from doing that. So if you don't buy health insurance and don't pay the tax, there's really no way the government can force you to pay it. So in other words, the Supreme Court said, because there's no real teeth in it, because you can't enforce it, and because it's so low, then it's constitutional. But the problem is, it's ambiguous now. At what point does the penalty become high enough that it's unconstitutional? The Supreme Court didn't say, which means if Congress ever raises the penalty, we got to go all the way back up to the Supreme Court and find out if it's still constitutional based on a higher penalty. Of course, where the penalty is right now, it's so low that it's not going to work. It's going to destroy the insurance industry and the healthcare industry, because based on a penalty that's so low, nobody will buy insurance. Everybody will simply wait until they get sick and then buy insurance after the fact, which means the only people who are going to be paying insurance premiums are sick people, which means there's no money to pay out the claims of the people that get sick because they're not collecting any money from the people who are healthy. Now, of course, the whole purpose of the penalty, if you don't buy insurance, is to force you to buy insurance. So the fact that it's ineffective, in my mind, is immaterial. The Supreme Court should have looked at the intent. And in fact, President Obama himself said that it's not a tax, it's a penalty. So the intent of the writers of the legislation is to punish people for not buying insurance. And the fact that they're doing that means it's unconstitutional. The fact that the Supreme Court is now saying, well, that was their intent, but it's not the effect because the tax is too low and therefore it's not going to work. The Supreme Court should not be rewriting the law. They should not be ratifying a bill that wasn't actually passed. The government intended this to be a penalty. They intended to punish people who did not buy insurance. They did not call it a tax. And the Supreme Court should have taken the government and the legislature at its word. I mean, talk about original intent. We know what the intent of this legislation is. It's to punish people who don't buy insurance. And the very Supreme Court that ratified it said that Congress does not have the authority to force people to buy insurance. For that reason, the whole thing should be struck down. But instead, they open up this little window and they say, well, it doesn't really force anybody to buy anything because the fee is so low that people will just not buy insurance anyway and just pay the fee. And even if they don't pay the fee, the IRS has no way to force you to pay it. But it's interesting, they said that Obamacare is constitutional because it's ineffective, because it's not going to work. But if they ever actually raised the fee to a level that was actually high enough to force somebody to have to buy insurance, well then by their own admission, it's unconstitutional. The question is, what's the threshold? How high would it have to go? And of course, how many more times do we have to go back to the Supreme Court? The fact that it's now so vague and ambiguous, it should be thrown out for that reason as well. But I guess you had the court looking for a reason to justify not striking it down, and they think they found one. But also, I want to go a step further. Let's assume that this is a tax, even though it's clearly a penalty, because we've never had the Supreme Court define a tax and measure it by the size of the tax. Right? It's a tax or it's a penalty, but now the Supreme Court says, well, the distinction between a penalty and a tax is how high it is. right? If it's low, it's a tax, but if it's high, it's a penalty. I mean, that doesn't make any sense at all because the income tax is very high and that's a tax. And I don't know, so the whole thing is ridiculous. But think about this. If it is a tax, it's unconstitutional as a tax because the federal government does not have unlimited taxing powers. The federal government is bound by the Constitution. There are two classes of taxes. There are indirect taxes and direct taxes. Indirect taxes, you pay indirectly to the government when you buy stuff, right? When you buy cigarettes or you buy alcohol, that's an indirect tax. It's part of the price of the things that you buy. The direct taxes are taxes that you write a check and you send it to the government, like the income tax is a direct tax. Now, when they first passed the income tax, it wasn't apportioned, and the Supreme Court said it was unconstitutional. They said, hey, this is a direct tax. You didn't apportion it. So they amended the Constitution. The 16th Amendment says that Congress can tax income without having to apportion it. Now, you can argue whether or not that took income out of the classification of a direct tax and made it an excise. Most people think that it allowed the government to tax income directly without regard to apportionment. But the 16th Amendment only mentions income. If the government is now imposing a tax on all American citizens that do not buy health insurance, that's a direct tax, right? Because it's taxing people based on the fact that they don't buy health insurance. And you pay the tax directly to the government. That's a direct tax. So in order for it to be constitutional, A, it has to be apportioned, which it is not, so it's unconstitutional. Or now the government's going to have to amend the Constitution, just like they did with the income tax, to say that Congress can levy a direct tax on American citizens who don't buy health insurance without apportionment. Now, this argument was actually raised to the Supreme Court. And here's what the Supreme Court said. The Supreme Court said it's not a direct tax. Well, how can that be? Of course it's a direct tax. I mean, after all, you pay the money, you pay the tax directly to the government. It's not even attached to an article of consumption because you're not consuming anything. You remember, you're being taxed for not doing something, right? So the tax is being applied to you as an individual based on something you didn't do. And here's what the Supreme Court said. The Supreme Court said that it's not a direct tax because it doesn't apply to every American. Yes, it does. It applies to every American that doesn't buy health insurance. That's every American. But the Supreme Court said, no, it's not a direct tax because only those Americans who don't buy health insurance are subject to the tax. Well, what does that have to do with whether or not it's a direct tax or not? The Supreme Court just made that up. It's an outright lie. I mean, think about it. The income tax was a direct tax, but it didn't affect every American. It only affected Americans that had income. There were plenty of Americans that didn't have income and therefore did not have to pay the income tax, yet it was still a direct tax. It was still declared unconstitutional because it wasn't apportioned. And in fact, even if you had income, you didn't have to pay the tax unless your income was above a certain threshold. When the income tax was first adopted, less than 2% of Americans actually paid it. Yet it was still a direct tax. Yet here the Supreme Court is now saying that the new definition of a direct tax is any tax that not 100% of the American population pays. So if there's one single individual out of 300 million that doesn't have to pay the tax, now it's not direct? I mean, come on. Talk about rewriting the Constitution, rewriting law, legislating from the bench. That's exactly what they did. They had to redefine a direct tax. We have a Constitution. Twice it says that all direct taxes must be apportioned. That's a constitutional principle. It hasn't been appealed. You can argue that the government can tax income without regard to apportionment, but that's it. They can't tax anything else. If they want to level a direct tax, they are bound by that. So the government can't have its cake and eat it too. In order to say that this is constitutional, they had to say it's a tax, not a penalty. But now, in order to say it's constitutional as a tax, they had to pretend it was an excise tax, even though it's a direct tax. So they had to lie on both fronts in order to get this thing through. Now, as an American citizen, I mean, I'm appalled that what the Supreme Court has done. But of course, there are a lot of bad decisions that have come down over the years. This is probably one of the worst. As far as what the effect is going to be, it's going to be horrific because number one, the penalties are not high enough to actually force people to buy insurance. And since we've told the insurance companies that they can't discriminate based on pre-existing conditions, that people are not going to buy insurance until after they get sick. So that's going to destroy the industry. To prevent the industry from being destroyed, the amount of the penalty is going to have to increase substantially. But now the Supreme Court has basically said you can't do that. You can't really raise the penalty substantially because now it might be unconstitutional, although we're going to have to bring it right back to the Supreme Court and find out if it's high enough. But this is going to hurt the healthcare industry. It's going to hurt the insurance industry. It's going to drive costs through the roof. It's going to further undermine the productivity and competitiveness of the U.S. economy. It is decisively bad news for everyone. I mean, the markets didn't necessarily understand this. They weren't down. They were down a little bit, maybe 150, 170 points early in the day. I don't know that that decline had anything to do with this decision. Meanwhile, the markets rallied back. I think the Dow only finished off about 25 points. Gold was down, pretty much about $20 the whole day. Clearly, if the gold traders understood the implications for the U.S. economy of this bill, gold prices would have been a lot higher on the day because this is negative for the economy. It means bigger budget deficits. It means more money printing, which means more inflation, which means more reasons to buy gold. So I don't think the markets really understood the implications of this decision. I want to circle back, though, and reiterate one point that we really need to consider. The Supreme Court, again, reiterated the fact that under the Commerce Clause, the government has no constitutional authority to force Americans to buy health insurance. Well, once they said that, they should have thrown the whole thing out because they said that the penalty or the tax for not buying it is low enough that it doesn't actually force you to do it. But the problem is once the tax is on the books, there is no limit to how high the government can raise it. Just because the tax is low now doesn't mean it's got to stay low. I think on principle, the minute you give the government the authority to tax something, and they've stated that the intended purpose of the tax is not revenue generation, but to modify your behavior, to require you to do something, even if the tax is not high enough to actually require it yet, the principle is still the same and they have to strike it down. I mean, for an example, let's assume the government wanted to require me to buy, broccoli. That was what they used in the Supreme Court. One of the justices says, well, can the government require me to buy broccoli? Well, according to the current Supreme Court decision, yes, they can require you to buy whatever they want because they can tax you for not doing it. Now, the Supreme Court is saying, well, as long as the tax isn't too high, they can tax me for not buying broccoli. But if the tax is too high, then it's unconstitutional. Well, where is that line? If there's a $100 tax on you if you don't buy broccoli, am I required to buy broccoli? If there's a $1,000 tax on me for not buying broccoli, am I required to buy broccoli? If there's $1 million tax on me, clearly, if the tax is high enough, I've got to buy the broccoli because I don't want to pay the tax. I mean, if the government made the tax so high that you would be impoverished if you didn't buy the broccoli, well, then obviously it's unconstitutional. That's the same thing with healthcare. They can't force you to spend a lot of money on it because then you'd have no choice. In fact, I would say that if the tax exceeds the cost of the insurance, then by this new definition, the Supreme Court would have to hold it unconstitutional because it would, in fact, force you to buy insurance. The only reason it's constitutional, according to the Supreme Court, is because the fee is lower than what it would otherwise cost you to buy insurance, so it's not actually forcing you to do anything. But again, the big thing is the principle, and you've opened the door. You've opened the door and you've established this legal principle that, of course, is simply going to get expanded and expanded so that ultimately the government is unrestrained in power, that we're going to create a government of unlimited power, unlimited taxing power, unlimited regulatory power, that there won't be anything that the government can't require you to do. Think about it. Think about on your own. Is there anything the government can't force you to do or prohibit you from doing through the use of the tax code? Clearly, they can't. And the Supreme Court, unfortunately, is allowing the camel's nose to get under the tent, even though the decision could have been worse, because they could have established the principle that no matter how high the penalty was, it's constitutional. At least they didn't do that. At least they said that they can't raise the tax to the level that would actually alter your behavior, because then it would be unconstitutional, because we know the government cannot do through the tax code what it is constitutionally prohibited from doing legislatively. Anyway, that's it for today. We'll see how this continues to work its way throughout the markets, through the political process. Obviously, the only way to get rid of Obamacare right now is to legislate it away. The Supreme Court is not going to protect us. But the problem is, based on the way it's just been upheld, the whole thing is going to fall apart, which maybe is the government's agenda after all. After all, they're going to destroy the insurance industry, destroy healthcare based on this bill, and then they'll be able to claim that the free market doesn't work and the solution is a single payer, complete socialized medicine, which is probably the agenda all along. That's the direction we're headed, and that is a total disaster. Bye for now.